Good morning to everyone and welcome to the latest Mason Hayes and Curran education webinar. This is the last webinar that we're doing in the current school year. Some of you may recall from previous webinars we suggested that we may run a further webinar in August around the reopening of schools issue, an ever-changing scenario. It seems to change day by day, so you might bear that in mind. Welcome back to all of you who attended any of our recent webinars, but a big welcome to anybody who's joining us for the first time. I'd like to introduce my colleagues. You're getting 6 of the education team this morning. My partners Liam Reardon and Paul Rochford, and my colleagues Catherine Kelly, Fiona Shiel, and of course David Ruddy. And finally, a word of thanks to IPPN and NAPD for their support and contribution to our webinar today. So the topic today is why you need to review your code of behaviour now. And we'll be asking that question of why now in a moment. If I could just make one preliminary point before we set off on the webinar. Today we'll be looking at situations when things go wrong around student behaviour. That's unfortunately the world in which our team lives. But all schools should be conscious that both the Education Welfare Act and the NEWB guidelines published under the Welfare Act actively encourage schools to approach student behaviour from a positive perspective. And indeed, Chapter 7 of the NEWB guidelines opens with the sentence, and I quote, "Promoting good behaviour is the main goal of your code of behaviour." And the guidelines go on to set out strategies to do that. For example, to encourage schools to introduce a reward system to encourage good behaviour. So this is just something to bear in mind if you're reviewing your code of behaviour. But today we're going to look at different aspects of the contents and application of your code of behaviour. And I'm going to start with the question that I'm going to put to Liam. Liam, review your code of behaviour. Why now?
Thank you, Ian, and good morning, everyone. That's a very good question. And the answer to it is twofold. There are 2 reasons we think now is the appropriate time to look at your code. The first is the consequences that flow from the coming into effect of the Admissions Act. And the second is the impact of the COVID-19 crisis. And both of these relate back to the statutory obligation on every board of management as an employer to ensure that the school is a safe place of work for staff and students. And so just looking at the Admissions Act, before it came into effect, we routinely advised boards of management to include a provision in their admissions policy, allowing them in certain exceptional circumstances to refuse to enroll a student who was perceived as posing an unacceptable risk to the health and safety of staff and students. We could do that because the Education Welfare Act allowed a school to refuse to enroll where its admissions policy gave the board the power to do that. With the coming into effect of the Admissions Act, that is no longer possible. For most mainstream schools, you can only refuse to enroll if you are oversubscribed. And so that got us thinking about how a school in the current time, how a school would deal with a threat posed by a student to the health and safety of staff and students. And that got us thinking about codes of behaviour. You will all be familiar with the precondition that's in the Admissions Act that allows you, or it's the only precondition that you can put to parents, and that is that they have to sign up to acceptance of the code of behaviour before their child is enrolled in your school. If they don't, the child isn't given a place. So that's the only, if you like, the only protection you have in terms of enrolling students. So we thought, how can the code of behaviour be made robust and fit for purpose in the current legislative reality? And so we think that it's important that there is something in your code of behaviour that refers to your statutory obligation under the Health and Safety Acts to provide a safe place of work for your staff and for your students. It's also vitally important that your code complies with the NEWB guidelines, and you'll be hearing more about that. If you get that right, it strengthens your position to deal with threats to health and safety of staff and students if that arises. The second and linked point is the COVID-19 crisis, which obviously we're all very much aware of. Come the autumn, when hopefully we're all back at school, it's very foreseeable that there will be behaviours on the part of some students which pose a threat to health and safety of staff and students. And you're going to have to be able, as schools, to deal with those situations when they arise. And for that reason, it's good to have something in your code that empowers you to deal with threats to the health and safety of staff and students. And that's really where we're coming from with this. So I'll pass you over now to David, who will talk you through some of the numbers.
Thank you, Liam, and good morning, everyone. In relation to the issue of suspensions and expulsions, we just had a look at some fairly recent figures. And as you can see there, many primary and post-primary schools, unfortunately, find themselves in a situation where they have to suspend and expel pupils, reluctant as they may be. And these figures for suspensions, don't take account of suspensions of less than 6 days. In your returns to THUSLA, your periodic returns, you have to account for suspensions of 6 days or more, or any expulsions. And also, it doesn't take account of the shortened day scenario. So it is expulsions and suspensions is a big issue for schools. So looking at this, what is the starting and ending point for this process? Well, the reference point is the National Education Welfare Board guidelines, and in 3 chapters in particular, which we will be looking at. And while they're called guidelines, they're not guidelines. And why is that? There are really 2 significant reasons. One, there's a statutory basis for them under the Section 23(3) of the Education Welfare Act. And secondly, over the last 20 years, our education team have been representing schools, particularly in relation to expulsion hearings. And the evidence and the knowledge taken back from all of these encounters is that the Section 29 appeal committees, which would consist of a department inspector, a retired school principal, and then another independent person, they stick rigidly and look rigidly at these guidelines. So in relation to these guidelines, I'm going to ask Ian, who has sat through many a Section 29 appeal hearing, to talk about what they say, the essentials. Ian.
Thanks, David. Well, I mean, on this slide, there are 4 bullet points which are taken from the guidelines themselves. As to issues which boards should consider in any, particularly in an expulsion situation. And we've had, extensive encounters with either situations where there's an expulsion hearing, for example, at a board, or indeed at an appeal hearing before the appeal committee, where these issues are put to the board, and the board is, if you like, confronted with whether the board has considered these issues before making an expulsion decision. Now, I'm not going to go through them one by one, but just to point out, the first bullet point and the 5th bullet point are really the same issue, and this is around substance and proportionality. Clearly, no board is entitled to expel a student unless it is a very serious situation, and in crude terms, unless it's kind of a last resort. But I do want in particular to point to the 4th bullet point there, the interventions tried by the Board of Management. And this is really something that comes up certainly at all Section 29 appeal hearings. So what interventions has the school made before the matter came to expulsion? You may well be asked, has an assessment of the student been done, particularly where the behaviour relates to or may be associated with a behavioural condition or some special need? Have outside agencies been involved? And if so, and if they've given recommendations, have their recommendations been implemented? And in short, really, is expulsion a last resort? And we'll be looking at scenarios where later on where we kind of drill down into what really last resort means. Thanks, David.
Yes, Ian, and a fundamental principle of law is the concept of fairness of procedures. And this is very apparent in relation to suspension and expulsions. Would you like to comment on that?
Yeah, I mean, what you've said there is accurate, a fundamental principle. There are really two aspects to any disciplinary decision. This would apply equally to employees, for example. One is a substantive issue, and we've looked at some of the issues around substance a minute ago. But the other issue is the procedural issue, and it's actually more often the procedural issue that is issues that are attacked at a Section 29 appeal hearing. So and we'll be looking at what fair procedures are. But the second one there the first one is right to be heard, and that's, obviously a fundamental principle. You will all be familiar with that one. But implied in that is that before somebody is afforded the right to be heard, they know what they're responding to. That they have been given the what we would call the case to answer, and some Paul and Liam will be looking at how that's put together. But it's given in advance of the hearing, preferably given it, or very important to give it in writing. The second issue there is the right to impartiality, which we'll also be looking at, which is around, absence of bias, and in particular, if it is the principal who is the person who is putting the case to answer, that he or she takes no part in any decision making. So these are really fundamental issues which we'll be looking at in more detail in a moment, but they're vital to get right.
Thank you, Ian. Catherine, you have worked a lot with boards of management in supporting them in relation to expulsions in particular. And one of the issues that comes up is dealing with students whose first language is not English. Would you like us to take us through a scenario that you've been involved with?
Well, we have had various requests made for a code of behaviour to be translated into different languages and for translators to be present at meetings. There's nothing in the newbie guidelines and nothing in the Education Act which states that the school has to provide that. They should maybe accommodate the parent in allowing somebody to come along, a family friend or a translator who would be able to assist them. The code of behaviour applies to the child, regardless of their nationality. Schools, I've gone into loads of schools where they would have the flags of the different nationalities of the children in the foyer. So there is no obligation to translate it for them, but maybe try your best to explain the contents of it. We did have a case where the mother was from Eastern Europe and she asked for it to be translated, and she wanted a translator and she wanted the school to pay for that. And we didn't agree to that. And when she took a Section 29 appeal, she asked the department, her representative asked the department to pay for it also. And notably, the department said that they were under no obligation to pay for that either. They would accommodate it.
So thanks for that, Catherine. And I'm going to come back to you in relation to many other scenarios that you have dealt with. Ian, we often get requests in relation to parents who won't cooperate in relation to disciplinary issues, and equally the question about parents wanting to bring solicitors to board meetings. Could you give us your views on these particular questions?
Thanks, David. Yeah, the issue about parents or guardians not engaging with the school when there are serious conduct issues in relation to their child, arises quite regularly. And it's really important that the school, first of all, makes all reasonable efforts to involve and to engage parents and home with the issues, the conduct issues that arise. And not only that they do that, but that they document that, because we've been in several Section 29 appeal hearings, and it's been really important that the principal, for example, or deputy principal, whoever it is, yearhead, has been able to produce a record saying we rang, we left messages, we sent out notes, we asked parents or guardians to contact. Really important. And we often say that schools, particularly in sending out a serious note, really emphasize to parents the importance of engagement when there's conduct issues. And for example, say to parents or guardians, you know, the experience at the school is that the best results will be got when home and school cooperate together. That's keeping of records is really important. Just a word there, we've put up there, what about parents who bring a solicitor to meet the principal? Well, that's a real no-no from our point of view. No principal should be expected to be confronted with a parent arriving to a school meeting with a solicitor. That's completely offside. Parents regularly ask to bring either a representative, which they're entitled to do, or somebody to accompany them to a board meeting in relation to an expulsion, or ask, can they bring a solicitor? It's not something that we would kind of suggest that you set out as of right in your code of behaviour, but where it's asked, we nearly always recommend that it should be allowed for, because, you know, we've been at many Section 29 appeal hearings, or we've heard boards tell us about Section 29 appeal hearings, where the parent says, perhaps quite legitimately, you know, they were completely overawed, if you like, in meeting the board of management, for example. They were coming in to meet 8 people and the principal. They didn't know their rights. They didn't know how an expulsion meeting would go. And in these circumstances, we really feel that on balance, you should allow a parent or parents or guardians to bring a solicitor to an expulsion meeting before the board.
Ian, if the Board of Management decide not to take that advice and to refuse to allow a solicitor accompany a parent to an expulsion meeting or whatever, and it goes to a Section 29 hearing, would that board be 1-0 down, as it were?
Well, Catherine and I have been in a couple of Section 29 appeals where a board refused to allow a solicitor to come. And you know, the parents got a lot of sympathy from the Section 29 appeal committee, where they were able to say that they were really, you know, out of their depth, out of their league at the appeal, at the Board of Management hearing. So 1-0 down is possibly a good description. It's something that really you should bear in mind. And one thing that's worth mentioning as well, I mean, some boards say, look, we would be intimidated by a solicitor coming in and maybe raising legal issues. So if parents are bringing a solicitor, it's also open to the board to have their own solicitor present, or indeed to have their own solicitor on standby or at the end of a phone or whatever, to advise the board on legal issues if they arise. So, you know, that's one way of dealing with that kind of concern.
Okay, Ian, thanks for that clarification. I'm now going to move over to Paul and to discuss the whole question of who actually has the authority to suspend. And you might take us through that and the time periods and that. So, Paul.
Certainly, thanks, David. So while on the ground, a lot of the activity in this area would rest at the feet of the principal, I think it's important to note that the actual authority under the guidelines rests with the Board of Management. Now, the board can and will delegate that authority to the principal. But I think it's also important to note that there is a requirement under the guidelines that delegation is done formally and in writing, are the words that are set out in the guidelines. And again, that should be more than a one-line email or a memo to the principal saying, yeah, you can drive on there and do as you see fit. So, you know, the guidelines stipulate that it has to be set out the limits that are on that delegated authority to the principal, also how the principal is then accountable to the board for his or her actions in relation to suspensions. And then if there are any other pieces that need to be reflected in that delegation, for example, from articles of management or from the guidelines themselves. So, and that is something that we've seen challenged recently in the case of an appeal of a suspension. You know, the question was asked, where was that delegated authority formally made in writing to the principal? And then coming out of that are the kind of timelines in terms of suspensions that we see there on the slide. So typically it is suggested in the guidelines that suspension should not be normally for any more than 3 days. And that would probably be the typical delegated authority to a principal. Then for things beyond 3 days, normally the authority of the board would be required. And also the guidelines state that if you are going to suspend a student for more than 3 days, it should be in exceptional circumstances. And also it has this qualification where that is required to achieve a particular objective. So, you know, we all might have a view of what exceptional circumstances might be, and they might vary from case to case, but there is this requirement to consider what are you trying to achieve by having that longer suspension. Again, then the board in its delegated authority may authorize the principal, subject to the approval of the board chair, to enforce a suspension of 5 days duration. And so that can be set out in the delegation. And that arises in circumstances where the board is not in a position to meet in a timely way in order to approve that longer period of suspension. And then the guidelines also state that generally the upper limit for any period of suspension should be 10 days. And that should also be set out by the board. And then obviously if you run into a situation, and we'll touch on this later, where you have accumulative periods of suspension in a school year of more than 20 days, then that triggers a right to a Section 29 appeal in relation to that. And then moving on to the question of appeals itself. So in terms of appeal, I know it's a question that we've had where you may put in place a suspension for 3 days on a student, and then the parent or the student automatically sets in an appeal. And the question arises, well, what do we do with the suspension while the appeal is being dealt with? And our advice has always been, look, let the suspension run, have the appeal, hear the appeal, and then if the appeal is successful, you quash or remove the record of the suspension from the student record. So, you know, there's no issue with allowing that discrete period of suspension to run while the appeal is being heard.
Paul, that'll come as a reassurance to schools, particularly in relation to health and safety issues and that, and we'll come back to you in a few moments. Fiona, would you take us through the different types of suspensions?
Yeah, thank you, David, and good morning, everyone. So immediate suspensions, they're fine if there's a clear risk to students and staff, health and safety, and it's necessary that the student is removed from the premises, then an immediate suspension can be imposed. Rolling suspensions, on the other hand, we don't recommend them. We say that they should be avoided. A student shouldn't be suspended for an indefinite number of days. And as Ian touched on earlier, the nature and seriousness of the behaviour is an important consideration. So a suspension shouldn't be imposed for poor attendance, for a student being late, or poor academic performance, or minor breaches of the Code of Behaviour. So that's important to look at. And also Paul touched on it, is that it's really important to advise a parent of their right to appeal a principal's decision to suspend. And in the case where a decision to suspend is made by the Board of Management, an appeals process may be provided by the patron. So just a couple of points there to be mindful of.
Fiona, can I ask you a question that comes up a lot is in relation to informal or unacknowledged suspensions, where the principal wants to suspend but doesn't put anything in writing, and the parent is happy to go along with that. There's no record, in other words, and yet the pupil is removed. Not a good idea, David. The NEWB guidelines, they don't allow for it. So the principal is required to report suspensions in accordance with the guidelines, and it's really important that a formal written record of the suspension is kept. So yeah, that's an important one. Thank you. On that cautionary note, we'll move on, and I'm going back to Paul here in relation to expulsions. Unfortunately, schools have from time to time to take this course of action, but there are basic ground rules. Paul, can you take us through them, please?
There are, David, and I think from your slide with the numbers at the outset of the presentation, you see it is thankfully more of a rare occurrence. And I think that is the general thrust and the general understanding of it from the guidelines in terms of a basic ground rule or basic understanding is it should be in extreme or exceptional cases. And as Ian touched on earlier on, you know, it should be a proportionate response to the type of behaviour that's exhibited. Obviously, we need to be aware of due process and fair procedures, and we'll be going into that in more detail later on. And it's important to note that you know, may be more difficult or need closer attention in a circumstance where there's likely to be high stress and you know, kind of a difficult situation for everybody, both the staff and school management, as well as the parent and the student. In terms of the authority for expulsion, that rests with the board, and it's not, unlike the suspension, it's not something that can be delegated. And then to all expulsion situations, there are these two strands that need to be dealt with, and Ian touched on this earlier: the procedural aspects of the process, and then the substantive behavioural aspects of it. And as we've said, most of the challenges focus on the procedural aspects. But in terms of the substantive piece, you know, this is the end of a process, or should be the end of a process. So as we've said, there should be an effort to exhaust all other possibilities first, where that is possible to be done. And in that context, it should be made clear during that journey towards this end point of the process that if the behaviour that's being dealt with continues, that expulsion is a possibility, and that should be made clear to the student and to the student's parents during the course of that developing process or developing exploration of other options. And then in terms of what the usual grounds might be in terms of the types of behaviour, you know, you're looking at behaviour that's a persistent cause of disruption to the learning of the class or the teaching of the class. Something that may pose a real threat to health and safety of students or staff, or, for example, a student engaging in serious damage to property. So those are all examples of the types of behaviour that we might be concerned with. In terms of the procedural aspects, I think if you are you know, a new principal or a newly constituted board, or if you are in a situation where you see a situation developing that might lead down the road to possible expulsion, and you haven't familiarized yourself with the procedures recently, it would be a good idea to do so. Now, you know, Liam is going to touch on the procedures later on in some more detail, but I think there are basic guidelines set out in the NEWB guidelines in terms of the steps of procedure that need to be followed. There's a very good checklist on page 82 of the guidelines that principals should familiarise themselves with in terms of how their thinking should be outlined in relation to it. And you also need to be aware of the Education Welfare Act, the provisions of that in relation to the procedural aspects. And if you run foul of those, and we'll be covering them later on, then you're probably more than 1-0 down, to use your analogy from earlier, David.
Paul, your beloved Liverpool was 4-0 down last night, but sorry, I'd
rather not talk about that. We'll move on to the next topic. The issue arises then in terms of things like automatic expulsion, and this is something that could be set out and should be set out by the board, and might be set out in the context of the Code of Behaviour about certain behaviours where the board will say in advance, look, if you engage in this type of behaviour, that is something that is automatically going to lead to an expulsion, and that should be done following consultation with the various stakeholders, so the staff, the principal, the students, the parents. But you need to bear in mind you still are under the obligation to engage in due process and fair procedures, even in relation to those types of behaviours and those which have been designated as automatic. And as with the final point on the slide, and the question that we will sometimes be asked, where you have a situation where there's a first offence, but it's of such a seriousness or such a gravity that expulsion is being considered, even though there may not have been anything with that particular student beforehand. And that is something that is contemplated by the guidelines but it is in exceptional circumstances. And the types of behaviours that are set out in the guidelines for that type of consideration, and this is not an exhaustive list by any means, but for example, serious threats of violence, actual violence, or physical assault on another student or member of staff, a student supplying illegal drugs to other students, or a sexual assault. Those are that's the level of seriousness. Those are the examples that the guidelines give us in terms of framing thinking in that type of situation. So it is allowed for, but it is exceptional.
Thank you, Paul. And bearing in mind what Paul has said about the different types of behaviours that would justify an expulsion, Catherine, you've put together a number of scenarios of cases that you have been involved in, and indeed other members of the team. So you're going to take us through them here just to demonstrate what a school can achieve.
Well, first off, as we always say, expulsion is a last resort. And most of the time, schools have been through everything to try and help the student. But teachers are entitled to come into work and feel safe, and children are entitled to their education. So sometimes when you have a student that is behaving like this, the last resort is to recommend, the principal needs to put together a report of the incidents to recommend to the board that this student should be expelled because they are a risk to the health and safety of others and they're very disruptive. So that's what I would say that you would need to do there. And we have been involved in numerous ones where we have held the principal's hand quite literally. I've had people break down in tears in front of me, principals, because of the stress that they are under in trying to sort this out. And we can help them through that process and try and bring it to a reasonable conclusion for them. If you go on to my first one, this was a 5th class student who was using sexual language. I mean, that first bullet point is just a taster. I couldn't actually say what he was saying in class in polite company, but let's just say it was pretty fruity. Spraying water on pupils, slapping pupils, threatening the teacher's child, throwing scissors. This was a really, really difficult situation. And the Section 29 Appeals Committee felt that his behaviour was at the most extreme end of the spectrum of misbehaviour. He was putting safety of others at risk, and he was terrifying students. And parents had actually complained to the board about the safety of their children and the fact that their opportunity to learn was greatly hampered. The Appeals Committee felt that his behaviour was very damaging and a persistent cause of disruption, and that's very important. They weren't allowed to learn. His continued presence in the school constituted a real and significant threat to his health and safety and the health and safety of other pupils and staff. So the expulsion was upheld in that case.
And the real and significant threat is the key sort of phrase.
Very much so, very much so.
Right, we'll move on to some other cases you'd like to discuss. And
This was another case which I was involved in. Aggressive behaviour again, foul language, disruptive. Quite relevant here, he was spitting on students. So, you know, with COVID-19 and all of that, that's an even more significant health and safety risk. The Section 29 Appeals Committee found that his presence and challenging behaviour in the classroom was having a serious detrimental effect on the education of other children in the class. That's very important. And they felt that the school had made reasonable efforts to respond to his needs. Also very important, the school had complied fully with the provisions of the Code of Behaviour. And there was a lack of communication between the child's father and mother. They couldn't agree on, you know, trying to get help for the child. And that was referenced in the Section 29 appeal decision. They also took into account that the class teacher and other parents had communicated to the board that they were worried about their health and safety due to behaviour.
I like that idea of communication with the board, even in advance of it going to that level of expulsion. And you've one final case there, Catherine, you'd like to take us through.
This is one that Ian and I were involved in, actually. A child who constantly suspended. They were trying their best to try and accommodate him within the school. Persistent aggressive behaviour, again, disruptive. The incident that led to a suspension and subsequent expulsion was he flipped over a table with 2 other children at it, left the classroom, threw a chair at an SNA and ran out of the school onto a main road. Huge health and safety issue there. And the appeals committee found that his continued presence in the school posed, again, a serious risk to his own health and safety and that of the school community. And his behaviour and constant bad language interfered with teaching and learning and created an environment of intimidation and fear. So very, very important. And his misbehaviours were a serious breach of the Code of Behaviour and Discipline of the school. So those are 3 cases we've been involved in recently that show.
And I think Catherine, that was a case where the class's academic performance improved dramatically after that child was removed.
Yes, and we actually could show that by the time that we came to the appeal hearing, it was clear that the other children in the class weren't having the opportunity to learn because of the constant disruption.
So this is the conflicting constitutional rights, the rights of that disruptive pupil vis-a-vis the rights of all the other children.
And it's a balance. It's not all about the disruptive child. It has to be balanced against the needs of the other children in the class also. That's very important.
Catherine, I think schools will take great reassurance from these scenarios that they indeed, and the staffs and pupils have rights, and thank you for sharing those. Liam, Catherine has gone through a number of cases where schools were successful. Equally, you have been involved in many of these cases, and it's not all plain sailing either. And you might tell us why or what we have to do to make sure it is. I think you'll have to unmute there. Sorry, Liam. Yeah.
Sorry, apologies everyone. Sorry, David. Yeah, to state the obvious, you have to ensure that you comply with the NEWB guidelines. So the principal is the prosecutor of the complaint, if you like. If you think of the principal's role as being the equivalent of the district attorney in the movies. So the principal has to prepare the case, has to ensure that a detailed investigation is carried out, and it's good to have notes in relation to that, to have evidence that the parents were requested to meet with you and so on, that the parents know the nature of the allegations that have been made against their child, and so on. So, and when the investigation has been concluded, the principal has to prepare a report and bring that to the Board of Management. And a key part of the principal's preparation for the board hearing is to ensure that the parents and the board have the same set of documentation. So obviously there has to be an oral hearing, a disciplinary hearing of the Board of Management. The principal needs to invite the parents to attend that meeting, giving them adequate notice. They need to be advised of their rights in relation to their participation in the meeting. And among those rights are, as Ian was talking about earlier, in terms of due process and natural justice, the parents have the right to make written and oral submissions to the Board of Management. They also have the right to challenge the principal on her or his report to the board. Indeed, the principal has to present her or his report to the board in the presence of the parents. The parents need to be advised that they can be accompanied at the hearing. And essentially, that's it. So once all of these requirements are set out in the NEWB guidelines, really key point, and Catherine has mentioned this already, I think, is that parents and the principal leave the board meeting at the same time. It's very important that the principal doesn't participate in the board's deliberations on this. And it's equally important that the principal is not perceived as in any way engaging in the board's deliberations on this. So we say, as a matter of practicality, the principal should leave the premises altogether, and both parents and principal leave at the same time. After that, I know Paul will be talking about the requirements of the Education Welfare Act, so I will leave that aspect of it to Paul, but essentially they're the key points, David.
Thanks for that, Liam, and it's really important that we have as it were, our ducks in a row in relation to successfully, as you say, prosecute a case.
Exactly.
Thank you, Liam. These guidelines, Paul, are rooted in statute, and there are some critical parts of the Education Welfare Act that you're going to take us through.
Yes, David. Well, I think it's important for boards to understand, schools to understand that once the board makes its decision, preliminary decision to expel, you're not at the finish line yet. You still have a bit of a journey to go. And the first step of that is, once that preliminary decision is taken, is to notify the Education Welfare Officer in writing of that preliminary decision and the reasons for it. And then once the notification has been sent, the Education Welfare Officer then, as provided for there in the legislation, subsection 2, has to make all reasonable efforts to ensure that provision for the continued education of the student is made. So 2 important points from that is, firstly, you should, as a board, make sure or confirm the receipt of the notification by the Education Welfare Officer, because, as Liam will touch on in a moment, the 20-day period that's set out in the legislation only runs from receipt of the notification. So you have to be able to establish the date of receipt, or otherwise your 20 days won't start to run. In terms of making all reasonable efforts, then the legislation goes on to provide how the Education Welfare Officer can go about that. So the first thing they can do is arrange individual consultations or meetings with the principal or person nominated by the principal, the student's parents, and any other persons that the Education Welfare Officer deems appropriate to contribute to that process. And then, following those individual meetings, then the Education Welfare Officer can convene a meeting attended by him or her and any of those persons that they would agree to attend such a meeting. And I think it's important, from the point of view, even though a preliminary decision has been made, that school management, principal, participate and make themselves available to participate in that process, because it is an important part of the process. And as I said, if you don't engage in this last step, you're going to run into difficulties at a Section 29 appeal if you don't fully participate or follow the provisions of the legislation that are set out.
Paul, thanks for your advice and steer, as it were, on that. Liam, you were involved in a very high-profile judicial review proceedings in the High Court a number of years ago in relation to what Paul has alluded to. Would you like to share with us the gist of what was involved in that case?
This was a case, David, where during the course of a friendly football match between students and staff at the end of a school year, a student decided to pull down the shorts of a teacher who wasn't amused by what had happened. The school wasn't amused, and they moved to expel. Ultimately, the matter ended up in the High Court, following on from a Section 29 hearing. And the issue that came to the foreground in the High Court was the interpretation of the Education Welfare Act. And in this particular case, the court found that the board had come to a decision that the student should be expelled before the passing of the 20 school days. And so that's why we advise boards now to, in the first instance, when they come to a finding, they express it as, not as a finding, they express it as an opinion that the misconduct warrants expulsion. And the reason for that is that the 20 school days only starts to run once you notify the Education Welfare Officer of the intention to expel. So the 20 days runs from confirmation of receipt of that notification by the EWO. And you have to allow for the EWO to do her or his thing in the interim period. And so it's important that that process is allowed to take place, because it's possible that the intervention of the EWO might cause the Board of Management to revise its opinion in relation to the intention to expel. And so you've got to just be careful in terms of the the appropriate decisions being taken at the appropriate stage. And so the decision to expel, the actual decision to expel, is only taken after the expiry of the 20 days as provided for in the statute. So it's just important to be careful of that.
Thank you, Liam. And on that cautionary note, we're going to just look at the do's and don'ts of expulsions. Liam, I'm going to get you to go through the do's, and Catherine, if you don't mind, the don'ts.
Yeah.
Both of you.
Yeah. Well, the first do is to make sure that your policy on suspension and expulsions is incorporated into your Code of Behaviour. Most schools have that already, but just make sure that you do. That's provided for in the NEWB guidelines. The second and most important point that I want to emphasize here is to make sure that there's a reference in your Code of Behaviour to the board's statutory obligations to provide a safe place of work. As I mentioned at the outset, it's no longer possible for a board to refuse to enroll a student who might be perceived as posing an unacceptable risk to health and safety. So you have to ensure, and you have to ensure in terms of your student body generally, that you're in a position to deal with a threat to health and safety as it arises in your school. Your health and safety statement already requires you to have a safe place of work. And so it makes sense that you would include this in your Code of Behaviour in terms of enabling you to deal with a threat of assault or actual violence, both of which are referred to in the NEWB guidelines, and both of which allow schools to act. But a key takeaway for us is just make sure that that's in your Code of Behaviour.
Thank you, Liam. And over to Catherine for the other part of this, the don'ts.
Well, the don'ts are, don't forget to notify the EWO of the board's intention to expel a student, and I would always advise that you would check that they have received it, just to be on the safe side. Don't forget to advise the parents that they may wish to be accompanied at the hearing, and I wouldn't get too hung up on the solicitor attending. Sometimes that can be a positive thing. I've been at hearings before where I have gone because the parent has wanted to bring their solicitor, and sometimes the solicitor is just there to reassure and guide the parent through. So it very much depends. Don't participate in the board's deliberations. As we've said before, it's very, very important that you leave with the parents before the board deliberates. You don't want any kind of perception that you are engaging in any kind of deliberations with the board. And don't forget to notify the parents of their right to appeal under Section 29. We'd normally do a letter out informing them of the expulsion and giving them the forms if they want to make an appeal under Section 29.
Thanks for that, Catherine. Fiona, much talk about Section 29 appeal hearings and that, but some new changes are now being proposed, and you have written an e-zine which will be published next week through Mason Hayes and Curran. Could you take us through some of these proposals?
Yeah, sure, David. So under the Admissions Act, all applicants applying to a school have to be admitted unless the school has failed or the parents fail to accept the Code of Behaviour. So given these really tight parameters around refusal for admission, under the new legislation, we expect that there's going to be a big increase in Section 29 appeals. So it's really important that schools familiarise themselves with the new provisions of the legislation and guidance issued by the Department of Education. So you'll see from the slide there some of the proposed changes under the new Section 29 process, and a notable one is that the existing provisions for a facilitation process to take place prior to the hearing of the appeal is removed. The department has commenced drafting the new procedures around Section 29 appeals, and it's expected that guidance is going to be issued shortly. So the takeaway here really is for principals and boards just to familiarise themselves with the new provisions of the legislation and the guidance.
Thank you very much for that, Fiona. And as we come to the end of our webinar, just some takeaways there. We would recommend that you revisit your Code of Behaviour and also your anti-bullying policy, which is part of the code. Any revision should obviously involve the Board of Management at the early stages. Please adhere to the NAWB guidelines for the reasons that we have referenced. You need to consult with your staff and pupils and parents, and that can be done remotely now, of course. We would bring your attention to our e-zines. I've already referred to the Section 29 one. Also, we have another one which basically summarizes this webinar in ways why you need to urgently review your code. And then looking at our other partners in education, the National Council for Special Education have a National Behavioural Support Service. And Ian at the outset alluded to the fact that we must look at the positives in the guidelines and equally supports we can get from outside agencies. The IPBN have a resource bundle dealing with pupils with behaviours of concern, and it takes you through again how you can access the different agencies, and you'll find it very useful, as is the NAPD document, the management of cyberbullying incidents. So at this note, I'd like to thank our education team, Ian, our head of education, Liam Reardon and Paul Rochford, Catherine and Fiona. And we'd like to thank you, all our participants, for registering with us and attending. And we just like to say, in this tumultuous year, which was all change and all challenge, we wish you well in your preparations to reopen schools. Ian will be writing to you with a link to this particular webinar. And hopefully, as Ian said at the top of the webinar, we may be returning to you with some supports in relation to reopening your schools. And in the meantime, we hope you take time to take a well-deserved holiday. So on behalf of all my colleagues and myself, thank you very much. Thank you.
Thank you.